Hello.
How's everyone? Feeling good, right? Now that you're nearing the end. Right?
Awesome.
Yes, I figured that. I figured that. I've been busy trying to write this final exam. I think it's too easy. I'm gonna have to make some amendments.
Let me write it.
Well, Lord, do you think you can write it tonight and send it to me so I can look at it?
If I write it, you got to send it back to us to do it. You can't look at it. You just have to say, okay.
Oh, that's what I must do.
Yeah, that works.
Oh, okay. If you say so.
That works.
Okay, if you say so. If you say so. I see quite a few people are on. How many on? 6? So who's not on? Where's Waltine? She's missing. 6 now. Well, you're also eager. That's just how much y'all want to get rid of me. All right. Hi, Yuri. How are you? He's busy working it.
I'm good.
Oh,
Yeah.
I figured you're busy working.
Good day,
Anyhow,
all.
tell Yuri hello. He's a busy man.
All is well.
Hey, they so happy they're narrowing down. They know Wednesday is the last class. Let's see what the Prime Minister says at 8 o'clock.
What he got to do with anything?
Well, I don't know. I see. Listen here. Rodney Monk is advocating a lockdown now. He's playing his song, Lockdown Baby.
These people doing what they want to. That ain't helping. That lockdown ain't helping. Them idiots doing whatever the hell they want to. I tired of them.
Listen here, these people, they know they have COVID and they don't care.
Okay? So him locking down ain't making no sense because they doing most damage in the day.
But the thing about it is that Rodney was the one from the very beginning who said, don't lock down this country, don't lock it down now.
Yeah.
Uh-huh.
Hey, man, Wayne Monroe.
Yes. Now all of a sudden, now it really real. Today he's saying, go get vaccinated. Go to the church, you got a prophecy. Hurry up, go.
Well, that's what Rodney Monk is saying.
Yes.
Because Wayne still ain't for the vaccine.
Oh, well, I'm still right there then. Get it again.
He was the one in the hospital crying, oh Lord, give me the vaccine.
You think he got it? You gotta wait till after. He's better though. Yeah, get it now.
He said he ain't taking it.
Oh,
Oh,
okay.
now because he's feeling it better.
He said that's an experimental, whatever that is, and he's not putting it on his body.
Oh, but you breathing it in though.
Okay.
What difference?
Every vaccine is an experiment. The only thing doctors do is practice. You know, look in the dictionary and find out what the word practice means.
Experimenting. Because when you go to doctor,
cut you,
experimenting. When you go to doctor and the doctor say, how you feeling, what's hurting? So you forget to tell him a couple parts. He give you medication or they give you a recommendation based upon what you tell them.
And they go right to Google and get diagnosis.
Man, I so done with that one.
No, so you have to have common sense. Yes, the vaccination will affect everybody differently. But what you prefer to do? Get a mild case or get the worst case and find out there's something you have underlying that you didn't know you had before.
Oh.
Let me give you a true story of a lady I know. She had eye problems, right? She had series of tests on her eyes. And all of a sudden she began to feel like a lot of pain in her bones and stuff. So they did some tests and they told us she had rheumatoid arthritis,
Oh my God.
right? They put her on a series of steroids and medication and all of that. So she'd been battling the rheumatoid arthritis while she was tending to her eyes. So beginning of this year, she began to feel so tired and she said, I don't know whether it's the steroids or what, but I think y'all should just run some more tests because I really don't feel well. You know what they came back with? Just 2 forms of cancer.
Oh my God.
2. So it wasn't rheumatoid arthritis.
What?
It was cancer.
Okay then.
Oh my
So
God.
were they not practicing?
Why you don't behave?
I don't know. But they was practicing. The only thing doctors can do, they don't know the be all, they're not the be all, the end all. So we have to understand whatever they doing, they practice in. And when they had the vaccine for the mumps, the measles and everything, somebody had to get started. Do you know that the vaccine for the measles and mumps have changed throughout the years? You think it's the same then that they was given 50 years ago is the same they're given now?
No.
Common sense.
No, it can't be the same.
Oh, I'm emotional when it comes to these law practicing and laws what they have on the books. But I'm also practical when it comes to, hey, look here, things change. And this vaccine was working today in certain areas. It's not going to work tomorrow because just like how this COVID-19 is having variants, so is the measles and the mumps. They say you couldn't get the chicken pox twice. I did.
I did too.
Okay.
I did too.
But the doctors tell you couldn't get it, but it happened. So can someone explain that to me? These are the same people from 50 years ago. Yes.
And my niece and I got it twice. And when we got it on a different part of our body. Because you know when you first get it, it's like on your legs and on your arms. We got it on our face only.
Oh, I get mine on my stomach only the second time.
Yeah. So it happens. It happens. All right. So you finished doing the people work. You ready to focus?
Yeah. We could start.
Oh, you sound like you're so tired. Today's only Monday. What happened?
This is be rough, man.
Oh, Lord.
In this group, which banks are closing at 1 o'clock or 2 o'clock?
I saw a sign up.
Royal Bank, Scotia Bank, I think.
Why?
Let's Commonwealth Bank don't do that.
Why you all closing at 1 o'clock?
I think
Caribbean Bank closing at 1.
Yeah, I saw that sign up. So Scotia still closing at 2.
Unfortunately.
We closing at 3:30.
We get close at 10. And I still want a full day fee.
Oh, Lord.
The fact that this is still being recorded.
You would you speak your mind here?
Oh, Lord.
The truth will set us free. No, but Commonwealth Bank never changed. From the pandemic start, we have been closing the same time. So it don't matter to us what they do.
the People's Bank.
That's crazy.
That's
It's
right.
People's Bank. So we gonna be in there to serve the people.
Yes.
These cases crazy though.
Yes.
9 people died on the weekend, eh?
Yeah.
You lie.
9 or
Yeah.
3. 9 or 3.
Well, I hear everybody calling number 9. So.
I hear 9. They say 9 passed and 200 and something in one day. Caught COVID
caught COVID.
That's that Cassie thing. Oh Jesus. I hope none of y'all gone to Cacique.
No, why? What was happening there? People like COVID?
That's where it started 2 weeks ago.
Oh, no. I didn't go there. And I didn't go to the church convention.
Oh, yeah, then the 2 places. Our whole family just was affected with that, child.
But where the people gonna find money to bury all these dead people?
You better
They have
burn
to-
them.
They had to burn them.
The mall overflowing.
Yeah, because I saw on Sunday they sent another notice out again. Say, please come.
Oh my God, people ain't got no money.
Come for what?
Come to the body.
Come for the
for
body.
the body.
The bank saying they don't want money out. And that's where they come to get the funeral money.
These people ain't
Hold
got-
on. That raises another point.
You're gonna get a
Someone said-
2,500?
Yeah, that's circular. What nonsense is that person right now?
What?
What's circular?
Hold on, where is this? Let me find it, man. I didn't even answer this in the chat because it's just so wrong. Let me see if I didn't throw it out.
They want the government to take care of them while they live and bury them when they dead.
Yeah, but hold on, no. This was someone who claimed that they are a banker.
Oh,
And then
Jesus.
yes, and they wrote this, they sent this thing around socially. Hold on. I hope it was not one of my students.
It ain't gonna be none of us.
Hold on, I can tell I find it right now.
Be
Because I said,
smart.
what is this nonsense? Oh God, where it gone? This person right. Oh, for everyone with a bank account, young or old, please add a beneficiary to your checking savings account.
Yeah, I saw that.
You saw that,
Yeah,
right?
I was supposed to ask you about that.
Asking me,
What is that?
you're a banking student.
That's why I said that's a lie from the pit of hell. But anyway, maybe something new changed.
Like what?
Yeah.
When?
I don't know. Y'all gotta tell me.
Then my heart breaks when I can't help parents and children that come to my bank with a death certificate, thinking that's all they need. No, ma'am, no, sir. You
Mhm.
now have to obtain an attorney, in bracket, $2,500 retainer, and become executor of estate and come to the bank to open an estate account, especially if the deceased have more than 50,000. Y'all, please don't put this off, please.
So which bank doing this again?
No bank will do that. This person named Tasha Renee. I don't know what name that is. So
I thought
somebody clarify that for me. Tell me what's the law. Let me hear you.
The law said you better have insurance.
Insurance law is one law. Don't forget now, we spoke about joint accounts and individual accounts. An administration of estate says that you are allowed by law to get $2,500 if it is on the deceased account.
Right. So the funeral
Then
home.
you produce the death certificate,
Right.
and you also produce a copy of the funeral home's invoice.
Right.
The check could be made
Yeah,
payable
that's
to the funeral home.
Right.
Right,
Now-
that's the practice, yeah. Anything else
Now,
to get a
when-
probate for, anything exceeding.
Exactly. And so anything that's over the 2,500, you cannot get it until you get a probate. And a probate means that you then have to go to an attorney who will then go and do all the background work to find out what are the assets
Yeah.
of the deceased. The deposit that the attorney will ask for is based upon the value of the estate.
Hmm.
So that'll be whatever assets that the person has.
Funny right now. It's the same amount of work.
What you mean? No, it's more work.
Really?
Mm-hmm.
Okay.
Because if you have a lot of assets, that means that is more research that have to be done.
Yeah. Okay. Okay.
Right.
Yeah, you're
So
right.
if you only have 50,000 in your bank account and that's it, no,
Mhm.
that's a small amount.
Yeah, you're right.
So after the lawyer has obtained probate for you, then you take that probate and you can go to the bank for the balance that's in the account if you are the executor.
Ever right that I was embarrassed as a banker. That's all
I was too. As
I
I'm
was
saying,
too
it was in the
embarrassed.
chat. It was in the chat and I didn't answer because if I had answered, my sister would have said, but don't you teach this? She would have said, this may be one of your students. And then that would
Oh,
be
that ain't
a
one
whole
of us.
argument. No. And then don't forget now, it depends on what type of account you have. And so sending this message out, all it did is just going to cause
Yeah.
confusion.
And people
That's
go-
bad though.
people
Yes,
go
it is.
To put people on
A non-banker.
Mhm.
Non-banker. So it was terrible. Anyhow, so let's talk about mortgages. Who does mortgages on a daily basis?
None of us.
None?
Mom,
Who's interested in dealing with mortgages? Nobody?
not really.
Nobody want nothing to do with target say.
A lot of
That's
pressure.
not good.
Mom.
Okay, so
Chapter 1.
we're finishing off chapter 9. We're like on page 102 because we're talking about the mortgage. when a person applies to the bank for a mortgage.
Okay.
So the mortgage document describes the parties to the transaction. And it also gives you the terms and conditions of the mortgage. So it tells you what your covenants, what it is that you're supposed to do, and then what the bank will do. It includes how much you need to pay, principal plus interest, and any other costs. And of course, when you see the mortgage documents speak to what you have to do, you have to make sure that those things are paying all of your, with all of the restrictive covenants, any regular, you do not own the land, and nor do you own the house or the structure that's on the land until the mortgage is completed. So the mortgage document also provides a description of the property, how the length of time that the mortgage is for, which is normally between 20, 25, 30 years, your monthly payment, the date that it should be paid, and what you have to be mindful of the date of payment is be very careful. Do not sign a mortgage where the payment is due on the 11th and you know you're paid on the 21st.
Right.
Because you will always be late unless you pay it in advance. It speaks to the mortgagor's redemption of the mortgage upon repayment of the loan, which means that once the loan is repaid in full, then the property, the house then becomes yours and you get back the land papers with your interest in land. In the event of default, what happens with the loan? And it tells you that the bank has certain legal remedies, such as foreclosure, power of sale, and the right to possession. The bank will also seek an opinion on title. So just remember when you would have bought the property, the purchaser and the vendor. The purchaser's attorney would actually do a report on title when you purchase the property. Now, when you get the mortgage, the same thing is done again. So what they're going to do is confirm or attest to the validity of the title to the property, and that's issued by an attorney to the mortgagee. That's the bank, to the bank. The mortgagee satisfies itself that it is legally in a position to grant the loan. And particular attention is given to the fact that it is not adversely affected by the rights of persons other than the mortgagor. So I can stop right there because this is the question that Yuri asked about. Yuri, remember we talked about adverse possession? And I said that we have a piece of legislation called quieting title.
Right.
Okay, all right.
That's when you
So,
definitely asked about the vacant land across the street that wasn't being used.
I have a case that you can read. I'll send it to you all after class. It's a case, it's called Montague Investments Limited versus Westminster. It's a Bahamian case. And it is about adverse possession. So when you want to adversely claim on a piece of land, you do know that someone else most likely owns that piece of land. And the law states that in the absence of evidence contrary, the owner of the land with the paper title is deemed to be in possession of the land, which means he's the person with the prima facie right to possession. And the law, without reluctance, ascribes possession either to the paper owner or to persons who can establish a title as claiming through the paper owner. So in order to say that you don't have papers for the land, but to say that you now want legal possession of that land, there's two things. You have to show the court that you have a sufficient degree of physical control and custody. So that means that you have factual possession. That's the part of the fencing in and the farming and letting people in the neighborhood see you doing these things. So they'll be able to attest that, yes, you've been doing it for X number of years. And the second thing that you have to prove is an intention that such custody and control on one's own behalf or for one's own benefit. And that in law means the intention to possess. So remember, I tell you, everything to do with law has to do with intent. So you have to prove those two things to the court. And you have to show that you have been in possession on that land, undisturbed, continuous for 12 years. And the court says that if the person who has the paper is asleep while all of this is going on, then the person with the adverse possession will take ownership of the land. So I'll send you this case so you can read it. Now, if you're going to read it before Wednesday, we could discuss it. Yuri, are you awake?
I'm here.
Oh,
I'm here.
oh, okay. I'm going to send it to everybody. I said, now, if you want to discuss it, we could discuss it on Wednesday if you're going to read it. Yes, no? It's not examinable.
Yeah.
Remember, you just asked for information.
Yeah.
We could read it.
Okay.
It ain't 79 pages.
19. You happy?
It's better than 79.
Okay. Yeah, 19 ain't too bad.
Okay. But I hope by now you've finished reading Makushla case because that question is already on the exam.
Well, that's a hard commodity. So I feel like I hope I can speak to everybody.
Yeah, what, Makushla?
Yeah, that's an interesting case.
As a matter of fact, I did some more research and it's really not that interesting. You know why? Because courts around the world have ruled the same thing in the same way.
You think so?
I know so. I just finished telling you I did my research. Because remember I told you now, moving away from doing too much of the checks, but more focusing on the electronic side of banking.
Right.
And courts have ruled in the same vein as they did for Makushla in other Commonwealth jurisdictions. The question what they now are fiddling with is whether, I think in the United States, there's some instances where the bank actually won, but there's more of it where the clients won. So it's interesting in terms of for us, because we've never had a claim such as Makushla's, but in other countries they have had them. And they call it the human versus scientific error. And ours went very, very long because they focused on the PFSA. That's what the bank tried to focus on, the PFSA, and saying that she should have been monitoring her account by online banking. And her argument was statements, when they should have actually focused on the ATM machine itself and the bank's duty and how the ATM machine works and her responsibility, which is the PIN. So that's why that judgment is so long, because they have more than one issue that they've put together. But what was the real issue? Was the issue her not monitoring her account? Or was the issue was that someone accessed her account without her
and
without
her knowledge, and the bank didn't notify her as and the bank didn't notify her as it was stated inside the PSFA.
You mean notify that the funds were taken off?
Well, the bank would not have known.
Notify
the bank would not have known.
That foul activity was occurring on the account.
The bank discontinued the updating of the passbook, eh? Was that it?
Yeah, but what I'm saying is that updating of the passbook is one issue. But what was the real issue? Because to me, when you read that 29 pages, it weaving the passbook and her looking at that to notice it. Rather than saying, you have an ATM, you have an electronic card, and by that card, this is how that card works. So if I am not here, how can you tell me that it is me? How can you do that?
Well, could have been her boyfriend with her pin.
Yeah, but they showed her the people on the screen.
But-
She didn't know them.
Yeah, well,
That wasn't stated in the case.
Yes,
That
it
was stated in
was.
the case? I don't think so.
They said in the thing that
I'll have to confirm that.
they showed her the persons, and she did not recognize them.
if I was, I would say the same thing. I don't know, I never see it.
No, I have to read that again. But I think you just said that they showed her the persons and like that was it.
Yeah, so if you showed her the person,
what they found,
she had to have said that
She
don't
didn't
know
recognize
the
them.
person. She
Right.
didn't recognize them. Yes,
Right.
that's what she said. She don't know them.
Convenience.
Oh Lord, here we
Because
go.
if that was my cousin, you
think
think
a
I
lot-
can say I recognize my cousin? Yeah,
I think a
that's-
lie detector test has been taken.
You really think so?
I mean, if I trying to get my money back, why would I say anyway? This being recorded. Let me try that.
Exactly.
No,
And
but
I already
this
get
is
it,
a
I can get
discussion
more.
for class. This ain't for the whole world to know. I mean, we're discussing things that happen.
Okay, yeah.
Reality.
So this
Yeah,
is
I mean,
published.
if I trying to get my money back from the bank with my cousin T, why would I identify my cousin on the camera? And who can say that's my cousin? I know the person.
Yeah.
Anyway, but she swore on the oath, so I guess we have to assume that she's telling the truth.
Okay. So listen, this is a case named Porter versus Citibank, and we digress from mortgages. I know how you all go. Porter versus Citibank. The cardholder made 3 unsuccessful attempts to withdraw money from an ATM on 2 separate days. Although the cardholder reported the matter promptly on both occasions, the bank allowed the debits recorded by the terminal to stand. At the trial, the bank admitted that the terminal was on average out of balance once or twice a week and conceded that due to a defect in the machine, the money could have been dispensed to the next customer. On these facts, judgment was entered for the customer.
And rightly so.
Rightly, yeah, rightly so.
Okay, so hold on, I have another one. In this case, a rogue who was standing near the bank's terminal memorized the PIN of a cardholder who was using a machine. The rogue who pretended to be engaged in the servicing of the terminals used an adjacent telephone to conduct a fictitious conversation with his employers, after which he asked the cardholder to let him have the use of the card so as to ensure that the terminal was in order. After withdrawing money by keying in the number, the rogue returned the card to the cardholder saying all was well. The cardholder contested the bank's right to debit his account with the amount extracted by the rogue, claiming that the bank had failed to introduce a safe method for the use of the card. The court gave judgment in his favor.
What?
Yes,
Yes.
it held that the
Yes.
bank had been negligent in not taking measures, for example, alerting cardholders to combat a ruse of which it had been aware. Again, it's difficult to predict whether an English court would adopt a similar approach. That was a decision made in a US court. Yes, they will rule against the bank.
If someone acts foolishly,
He pretended they thought he worked at the bank. He pretended to be working on the machines.
So be careful when you're getting rid of your uniforms.
And so you see what the court said? The court said a ruse like that, the bank should have sent out notices of being aware of ruses. So that means anytime you see these skimmings and skirting, that's why they keep publicizing it, so that you are aware.
So is that the case where the courts are still slapping the banks on the wrist because we are considered as professionals?
Yes. You have to think of all
Wow.
areas of risk when you doing these businesses. All.
Now the person get his number.
because he should have protected his PIN.
No, but the bank has to do diligence to make sure that if you're in there, the screen is protected and no one can see it. So
Exactly.
if someone walks into that thing, and they have to pass you to get to the next one, the bank did not do their due diligence.
Okay, so here it is.
Think about it.
This is the question the court left open for discussion by academics. Is he, the customer, to be held liable for his failure to prevent a person from looking over his shoulder? That's the question the court left for the academics to discuss and bankers. Is the customer at fault if someone could look over their shoulder and see what they're keying in?
No.
And the answer is no.
No, because you're engaging in some place where you're supposed to feel safe and secure, that the bank did their due diligence to make sure that no one can see your PIN or whatever. That means if you're keying in and you have to keep looking around, you're not given a safe place to do your banking.
Wow.
I don't know. Maybe I'm wrong.
No, but it is. That's what the court looks at.
Wow. Okay. A little surprising to me, but okay.
You didn't think that?
No, I mean, I guess because I make sure I'm suspicious of everybody, and I make sure that I make sure that I'm safe, and I guess I feel like it's my responsibility. But I get your point.
Yeah, but don't forget now, he pretended he was engaged in servicing the terminals. So how many times have you gone in and you see a bank employee say they're servicing the machine?
I've never.
It happens. You never seen it?
No.
Sometimes you see them there. Sometimes you see
they service them
the
from
bank
inside the bank.
Behind.
Inside the bank. You never see anybody in front of those machines servicing.
But hold on. But if they're not a frequent person, they may not know.
If I walk into a ATM and somebody's in there servicing the machine, I am suspicious.
Thank you.
But everybody's not like that.
But all my life, I've never been seeing nobody servicing those machines from the front.
That's in the Bahamas, but in the US, they do that.
But I can only speak for here in the Bahamas.
But you do use the machines when you go to States, right?
I do use them, and even then, when I walk in and I see somebody hanging around, I'm suspicious.
Yeah, I leave.
Especially over there.
So I feel funny too. I won't wait till because normally I'm in the car with somebody, and I rather wait till you come out while they're there with me. So I still feeling some type of way about that in the States as well.
Yeah. Yeah, you gotta be more aware of your surroundings, and you can't be trusting people. I mean, the bank can't. I mean, this person didn't exercise good judgment, man, in my opinion.
Okay. So in the case of Fieldman versus Citibank, the customer had again went to the bank saying that the bank owed him, I guess, an extra sum of money because an extra withdrawal was made by his card. But the bank argued that the customer, had been fraudulently induced to make that extra withdrawal by the person who was standing next to him at the ATM. So the bank is saying, you cannot say it's the bank fault. If you're standing outside by the ATM machine and this person is talking to you and you are on this person back, then you were fraudulently induced to make that extra withdrawal. You cannot blame that on the bank.
That's on them.
And the court took the side of the bank.
My God.
Oh,
yeah, the court took the side of the bank because he had someone standing on the side of him. And they saying that you're saying you didn't make that, but the bank is at fault. So the court said, well, you were induced by the person standing next to you. And so he said the withdrawal, but the court ruled in favor of the bank. Yep. So there are cases where, quite a few cases where people have claimed against banks for monies. All right, so I can send you the case on adverse possession. So let me finish. Let me go finish this paragraph. Again, it says important that the mortgagee satisfies itself that is legally in a position to grant the loan, and particular attention is given to the fact that it is not adversely affected by the rights of person, especially in light of the provisions of the Inheritance Act regarding the rights of spouses and other pertinent statutory and common law principles. So everybody know what the provisions are under the Inheritance Act. If there is no will.
Yeah.
It still doesn't go to the oldest, right? No more.
No.
Okay.
There's no will and the person is married.
What happens?
The spouse gets 50% of the estate and the other 50% is shared among the children.
Right.
What if there's no children?
If there's no children, then the spouse will get 100%.
Takes all.
Right.
Okay.
That's why it's important that you write a will.
Yeah.
Very important. So if there's no wife and no children, then who gets it?
A sibling?
The mother.
Estate account?
The next of kin.
Who's the next of kin?
That would be what, the father.
You're saying someone else.
It's not a parent.
Parent?
The parent. Yeah. Or the
If they're living.
siblings, if they're dead.
Or on a estate account?
If there is no husband or wife and no children, it is distributed to the grandchildren.
Grandchildren?
Yes.
They have no children.
They have no children and they no grandchildren. Don't the parents get it?
No, your children could be dead, but that don't mean you don't have any grandchildren.
Right. But what happened to the parents?
But they come further down.
What if
So
you
that's
don't
after
have
the
any
grandparents.
kids?
Okay,
After the
so-
grandkids.
If there's no children, no husband, no wife, no children, no grandchildren,
Send the parents.
then it goes to the parents.
And then the siblings say.
And then afterwards, if there is no husband and wife, no children, no grandchildren, no parents, then it would distribute it in a different manner. It goes to the brothers. It goes to the brothers and sisters.
Right. Okay.
And when the government steps in.
The government stepped in when there's nobody. Then it go to the nieces and nephews. Or to the grandparents. And then the uncle and aunts.
Oh, wow.
So, yeah. So that's why you should write a will.
Amen.
So that's when you talk about Inheritance Act, that's what that's about. So the stamp duty on the mortgage loan is normally 1% of the amount of the mortgage advanced to the mortgagor. And the mortgagee protects the security rights under the mortgage property against third parties, such as subsequent mortgagees or purchasers of the mortgage property by recording or registering its security over the property by having the deed stamped at the public treasury and lodged for recording at the registry for deeds and documents. The mortgagee often takes possession of the original title documents, including the original mortgage, after recording at the registry of deeds and documents. So once the mortgage is signed, sign the documents, then the requisite registration is made and the bank retains those documents. So you don't get them back until the mortgage is paid in full. The mortgage is to the date of recording of the mortgage document. So according to Bahamian law, is the first in time. When the mortgage has paid off the loan and the property becomes free of the mortgage granted over it, the mortgagor has effectively what they call redeemed his property. So during the currency of the mortgagor has residual rights in the property known as the equity of redemption. And I explained that to you before. If you have a mortgage and you start to pay your mortgage down, you can actually use your equity and redemption to get another loan. If you require more than the original amount, then it'll have to be an upstamping. During
They do second mortgages over here.
if they do them? When you say second mortgage of a different property?
On the same property.
Yeah, you could get a further charge.
Interesting.
Yeah. So say when you got the property is valued at 400,000, but you only needed a mortgage of 210. Right? So you paid down your mortgage for the last 15 years. You've made a lot of improvements. So now your property is valued at 475 or maybe even $500,000. So what you do now is you can get your property, your mortgage up stamped. From the 210 you borrowed to maybe 300, whatever's the percentage that the bank would allow you to borrow based on your disposable income and making sure you're not over the percentage.
So can you go to another bank and get a second mortgage on that same property?
They don't like to do that. No, they don't like to do that.
All right.
They don't like that. What would normally be recommended to you by the bank you're getting the second one from is they're going to ask you to bring the first mortgage over to them. Because you're talking about the same collateral.
Yeah.
Right. They don't like to do that. So the equity of redemption is the rights of a mortgagor over his mortgage property, particularly the right to redeem the property at any time on payment of the principal, the interest, and cost of the mortgage loan. The value of the equity of redemption is the value of a mortgage's unencumbered interest minus the value of the mortgage loan. Now, the law governing mortgages in the Bahamas have ensured that the mortgagor is protected from any undue advantage by the mortgagee by ensuring that if a transaction is in essence a loan on security, it is treated as a mortgage, notwithstanding its form or the words of the mortgage contract, and by ensuring that there are no clogs or fetters on the equity of redemption. So, people always say, why the bank always giving these people loans and they're getting older or they're getting loans to send their children off to college. Why don't they just tell them no? They can't. Because as long as they qualify, the bank cannot clog a client's redemption, which means that if they have sufficient disposable income and they can qualify for it, they can use the equity in their home. Similarly, the courts are being cooperative and assisting mortgagees in exercising their legal rights and remedies against defaulting mortgagors. So when we speak about defaulting mortgagors, then we have to take a look at the new legislation, which is the Homeowners Protection Act. Bankers, have you read it?
I understand it.
What do you mean?
Then they brought that out about, I want to say 3 years. 2, 3
yes,
years.
you're correct. You're correct. 2017.
I know the bank that sent something out and I was reading what the bank sent us and I was like, it's too much.
What's too much?
I didn't understand. I stopped reading.
Oh, Lord. But how do you know if something were to happen, you had a mortgage? How do you know what your rights are if you haven't read it?
That was too much.
Too much? Everybody has a copy of it? Because I could send it when I send the case.
No, I don't.
That was almost 20 pages,
No, it's 14.
Oh, well, the one what they have from the government there, that's the one that I was looking at.
So the first thing it gives is the protection for mortgagors. That's the borrowers. And the first protection you have is that the bank is obligated to give you notice prior to instituting court proceedings. So it says that where the borrower is in breach of the mortgage agreement, the bank shall not commence proceedings before the court in respect of the breach unless the borrower has been served either personally or by registered post, no less than 30 days prior to. And when they send that notice in writing to the borrower, they have to state what is the nature of the breach of any covenant that they have in the mortgage agreement. So the mortgage agreement has covenants in it. They have to quote with section of the actual mortgage document that you have breached. They have to state the amount of the arrears the mortgagor owes. And I can tell you now, I've read cases where this second point is really a tough one, because the bank is quoting one figure and the reports from the system is reporting a different figure. And when the borrower had gone to the bank to find out what his balance was or what is due, it was a different figure. And the court have sent them all back to the bank and saying that the bank cannot move any further until the bank comes to an agreeable position as to the exact amount that the mortgagor owes. So the second thing is the amount of any administrative or any other costs, which means any real property tax that's outstanding, any insurance that's outstanding, any action by the borrower has to be taken to say what steps have they made to try to cure the breach, or what have they done to avoid foreclosure, or what have they done to try to cure the sale of the mortgage property. Then they also have to say whether or not there's any other rights that the borrower has underneath the act itself, the Homeowners Protection Act, that they can rely on. The bank also, in that notice, when it sends it to the borrower, the bank has to say whether or not they're willing to discuss the breach with the borrower and whether the bank is willing to enter into an agreement to try to redress whatever the issue is, including looking at a modification of the terms of the mortgage. And then the bank then has to give a contact, an address of the person and a telephone number whom the borrower may speak to. So that's your right as the mortgagor. That's the first step you have to do. So once you receive that, then you go apply to the court for relief. So that's why I think it was important when they gave it to you all. They should have had like a training session, maybe in 2 lunch sessions. So one, you know what is your right as a mortgagor, and then from the bank's perspective, what is expected of the bank. Because after that, then you have to go to court, the borrower.
Is that true?
And the bank, yes.
You said something about the mortgagor being able to go into the bank to see someone in person. Because I know more and more now, you know, the in-person meetings are not really being encouraged. So, I mean, that wouldn't be a breach. I mean, if the bank says we'll have to have a teleconference. That
no, long as there's a person. Because it says which a mortgagor may come in person on a telephone number. But of course, you know, if you have the COVID emergency orders, then of course you have to adhere to that.
Right.
But it's just that it has to be a person that they can talk to, not a machine.
Okay.
Yeah, not a machine.
Okay, so once this goes to court, say the bank wins. What is it says the time frame is up to 6 months to vacate property. Within that 6 months, is that person still required to be paying on the mortgage, or they're just there for 6 months?
Okay, hold on. Because the next step is about postponing the sale.
Okay. Sorry.
Yeah, so hold on, let me go. Where are you getting the 6 months from?
I tell you, I read over this thing
Okay, so yeah, I see it. So a mortgagee, that's the bank, an exercise of his power of sale. So let's say they're going to move to the power of sale now. They cannot engage in any unfair, deceptive, or abusive acts or practices. So where the bank has failed to secure a sale of the property at market value within 6 months from the date of the mortgagee, either issued the notice or obtained vacant possession. So they already have vacant possession. So the mortgagee at this option, after giving notice to the borrower, they proceed to accept the highest qualifying bid offered in writing. But why would you still be paying mortgage? It's up for sale.
Okay.
Because the sale price is the balance as at that stop in time.
Gotcha.
Say what? Pardon me?
You're talking about vacant possession. So when we go to court and say I hadn't paid, so they say, okay, the bank wins. And what the time frame for you to be out of this property, say they give you 6 months, 3 to 6 months to move out. Within that 3 to 6 months, the bank isn't, that means the mortgage stops, the interest on you stop, you no longer own it, it's the bank on. Correct?
Mm-hmm.
So that
the bank takes it over after the 4th month.
Okay, so within those months, you ain't paying and you basically living free.
Yeah, you should be having discussions and restructuring.
Okay.
I lost. Discussions and restructuring, you mean restructuring the mortgage?
Yes.
So you should be paying them.
It depends on when you having your discussion, can you restructure?
Mm-hmm. Because I know for restructure, you have to meet a payment plan.
Right.
6-month period, okay.
Right, but if you can't meet it, then of course, you gotta come out.
Right, okay.
So it says here, where is this? Go ahead, say it.
No, but the interest continues to accrue on the mortgage. I mean,
of course.
Right.
Yeah.
All
but don't forget now, once they put it up for sale, they have to get what is the best price in the market.
Right.
And there have been cases before the court where the banks put the houses up for sale, but they were not sold at market value.
It very rarely is. I mean, maybe 80% of market value. This is a lot in the diary already.
What the courts have been finding out is that the banks were not going out and getting current appraisals. They were using appraisals on file.
Okay.
And so the mortgagor complained because, at the end of the day, they got nothing back. So they would have paid back $40,000, $50,000, $60,000, $80,000. And at the end of the day, when they sold it, they got nothing.
Right.
Okay.
The bank is only looking out to get whatever is due them.
Yeah, but by law, they're supposed to get the best price.
So that means that the bank will have to go out and get it reappraised?
Yes.
Yes.
So they have to take that fee on too.
No matter how you look at it, the bank is not going to lose.
Because that's going to be incorporated in the sale price. And that's going to be taken away from whatever the previous owners would have owed.
No, it's okay. So say they have a loan on the books and the balance is 180. The last appraisal was 275. And that appraisal was done 5 years ago. And they go in and they sell it for, they say the best price they could have gotten was 250. That mortgagor can sue. Because you need to know what is the value of the property now, today. You're selling it now. You're not selling it 5 years ago.
Okay. So once the sale comes in, they take out what the person owes and all the administrative fees that goes along with it, and then the mortgagee gets balance the difference.
Yes.
Okay.
The mortgagor gets the balance.
Okay. Now I got my clarity.
In an ideal world, yes.
Sorry?
I said in an ideal world, that is what happened.
No, you have to sue.
Yeah. Yes, ma'am.
Right. And see, there's a prohibition in this. It says that where the mortgagee exercises his power of sale, they cannot sell a mortgage property to a director or employee of the bank. No immediate family of any director or employee, no company that is owned by a director or employee, or any person who by the nature of their intimate relationship with either director or employee, they cannot sell the property to any of those people. The spouse, the children, the parents, the sibling, the cousins of any employee or director of that bank. It cannot happen. That's a conflict of interest.
No friend, family, and lovers. Okay.
No.
Okay.
So the part 3 of the act says that a mortgage or the borrower may, not more than twice in any year, request in writing to the bank to furnish them without any charge or fee, a statement in writing setting out with respect to the mortgage, their principal, your interest, and any other costs and fees owing. So this is the only way you, at the end of the day, can go to the court and challenge when they say you owe $15.75, and you can pull out all of your statements because you're allowed by law to get it free twice a year, and say, how in the world can it be this? And I was paying this all along. Because I'm telling you, the cases have gone to the court where the balances are not correct.
Wonder what bank that is.
I'm not telling you nothing. The bank upon request, and that is within 30 days after receipt of that request, and without reasonable excuse, if they fail to do so, any rights they have for the enforcement of the debt or mortgage, or for the cancellation or specific performance in terms, shall be suspended until he has complied with the request. So this section right here, section 15, subsection 2, says that when you ask for your balances, the bank must give it to you, unless they have a reasonable excuse why they can't give it to you within 30 days. And it says that if they cannot give it to you and the excuse is not reasonable, then they cannot force you to pay. Then it says the borrower, that's the mortgagor, have a right to choose the attorney and appraiser for mortgage transactions. You see, on the mortgage of any property, the borrower should be permitted at his expense to retain and instruct a counsel and attorney chosen by him from a list of attorneys approved by the bank. He can also select an appraiser of his own choice, provided by the list of at least 12 names of appraiser by the bank. Here, every bank has to publish on his website or circulate a newspaper list of approved attorneys along with the criteria for why those persons are on the list. And you do not have to pay for any attorney fees that are not related to your mortgage origination and modification. And then it speaks in part 4 about the employer's obligation with regard to salary reduction request. So that's that, and then there's just the offenses and penalties. So all it really does is it gives you time in law now for the mortgagor to sit down with the mortgagee and come up with some form of arrangement. And then if the bank is going to sell, just to make sure that you get a fair market value. And so people don't say that they're blindsided. So even though the law of conveyancing said, if you miss 3 consecutive payments on the 4th one, then the bank kicks in and it can begin to exercise its powers. But what this act is saying is that before the bank can kick in its powers to take a legal remedy, that is either a power of sale or foreclosure, or bring an action in the court to recover the debt, they're saying that you have to get notice. And then it actually tells you what the notice should contain. So the bank has several remedies. An action for debt, it could sue you for what you owe them. Or if it's a mortgage over an actual business, they could appoint a receiver to manage that business. Or you could have forfeiture, or they could just take possession, or they could just decide to sell it. Either or. So that's what the homeowners protection bill is about. So I'll send that along with the case. Yuri, I wouldn't send the Quieting Titles Act unless you want it, because it's really written in Old English.
Oh, never mind then, because yeah.
I'll send the case
that's
instead.
okay.
No, I'll send the case.
Okay.
I'll send the case. Anyone wants the Inheritance Act?
Yeah.
Or you prefer to write a will?
I can write a will, but I want to know about that though.
Okay. I'll send you the Inheritance Act.
Knowledge is power.
Huh?
Knowledge is power.
Yes. So I'll send that, and the case. Okay, Montague Investment versus Westminster. Okay, all right. So let's go to chapter 10, legal issues, defenses, and remedies. So we know page 105. So we know the banker customer contract has both express and implied duties and rights for the banker and the customer. The legal issues which arise in banking law often relate to some breach of those duties and or the recognition of the rights of the parties to the banker customer contract. The legal defenses and remedies available to the parties to the contract are dependent upon the actions of the parties in operating the account, complying with the bank mandate, and mitigating risk and or loss in banking transactions involving parties. So whether in the role of plaintiff or defendant, some of the important consideration that must be taken by the bank and customer in commencing or defending a civil action for breach of contract, negligence, the tort of conversion, or some other civil wrong are the cost of the action, time involved in adjudicating the matter, publicity, convenience, and the need for ruling. All those things you have to think about, the bank should think about before it makes a decision whether or not it's going to take a matter at the court. So if we take the Makushla matter, that was quite a sum, right? That the bank refused to pay. In one of the cases I mentioned to you all, that was similar to Makushla's, the bank actually took the client to court for $800.
That's ridiculous.
They had refused to pay.
They deserve to lose that case. So they have lawyers that they refer these things to?
Yes. But that's what they talk about now. These are the things that the bank has to think about. The cost of the action, the time involved to adjudicate it, the publicity, that's the reputation, the convenience and inconvenience, and of course, the need for ruling. The need for ruling means that, do you really need the court to make the judge to make a decision on this matter? Because the reputation is one thing. But now it comes back now that the bank itself does not exercise the duty of care towards its customers. Because the client was not arguing for $800 or $400 or $50. They're arguing for thousands of dollars that happened on 2 separate occasions. So banks are often advised to take a practical approach to resolving legal issues before proceeding to commencing an action or initiate legal proceedings. All facts should be investigated, reviewed, and analyzed in order to determine the strengths and weaknesses of each party's legal and/or commercial position in the context of the duties and rights of the parties based upon the banker-customer contract. And now you see why the judge normally says that the burden of proof rests with the bank. The bank owns the ATM machine. The bank knows the configuration. The bank knows how it works. So you're gonna have to prove to the court that what the customer did was a breach of contract. And that's the reason why you shouldn't have to pay. I don't see anywhere in that case that we read where the bank demonstrated that they knew the mechanism of the machine and how it worked. You could tell me if you figured otherwise when you read it, or anyone. Did the bank demonstrate that they knew how the ATM machine worked? To stick to that hard and fast stance twice, that they would not repay. What were they standing on? Just the PFSA? That she should have looked online?
Yeah, they were standing on the fact that she didn't monitor her account, that she should have monitored her account properly and notified the bank in time. That's why they were hesitant to pay the money back, because she didn't notify the bank of the charges and the timely manner.
But they also had the duty, you see.
Yeah, they also had the duty to notify if anything fraudulent or anything abnormal was happening to the account to the client.
Because it was out of the norm.
Right.
And the bank's legal counsel convinced them that she didn't have a leg to stand on.
But I'm still trying to figure out why, especially in the second time when she said I was not there. And she had already changed her PIN and got a new card. What I'm saying is that when you read the case at all of that pages, how many pages is it again?
79.
I know you all know what you had. See, that's 79. I don't see where the bank itself and the expertise in the bank demonstrated that the machine itself was at fault. To use that as the basis upon which they denied it the second time. You saying you didn't monitor your statement is one thing, but the bank has a duty of care. So how are you demonstrating to me that that machine was not at fault? Because when you come back to the end, when they said that it was a skimming, the bank should have already demonstrated in the evidence that they produced how this machine works and what the machine is susceptible for and how the bank mitigates against that risk. And then you could have turned on the point that you should have been monitoring your account, which would have been slim. But I don't see where they spoke about the machine itself and how the machine operates and the mitigating factors that the bank takes into consideration in the use of the ATM machine and any possible mechanical or rogue transactions that may occur. You get my point, Yuri? Yuri.
Yeah, I got it.
You understand my point?
Yeah.
No, I say if you understand my point.
Mhm. Yeah, you got it from.
Mm-hmm. Because looking at the statements is one thing. But I think the bigger issue to me was, how did it happen? How did the bank allow it to happen?
Oh, but honestly, now the bank has like thousands and thousands of clients, right? So you
Mm-hmm.
really think the bank is gonna like nitpick and look through all these accounts to see like the
That's
check
my point.
abnormalities?
Right. But that's my point. That's what I'm saying. The argument should not have been around that. The argument should have been around the machine itself.
So you're saying the machine should have noticed the error before?
No. In the affidavits and the investigation that took place prior to, when you look at the issues that are before you, right? The bank should have demonstrated that these ATM machines are capable of doing these things. How is it that you are off the island and funds are being withdrawn and you got a new card? Think about it. You're supposed to be able as a bank to know what are the risks in the use of the ATM card and whether or not all of those risks are being mitigated, in order to stand up twice to say, no, I'm not paying you back this money.
Okay.
Forget the statement and looking at it. I agree with you. Customer can spend all day long looking to see, oh, $1 gone. Oh, 50 cents gone. When will you ever live? That means you don't trust the bank. I'm saying the crux of it came down to that machine. How did that happen? So when the second incident happened, the bank should have picked up that there is something fraudulent going on. And instead of the bank using as its defense the booklet, it should have tried to mitigate against that risk by putting in measures against such fraudulent activity and coming to an agreement with the client. And this would have never been in the public domain, because now it hurts the reputation. And it can be used as an example in any Commonwealth jurisdiction around the world, because it's public information now. So some of the legal issues that may arise in banking law: the existence of the banker-customer contract, breach of the bank's duties, breach of the customer's duties, enforcement or non-enforcement of the bank's rights, and the same thing with the customer's rights, breach of a duty of confidentiality, customer versus bank's right of to appropriate, a role in Clayton's case, wrongful dishonor of a check, safe custody. Hold on. Wrongful dishonor of a check. On Wednesday, am I going to see that document from ACH? She's not on today. I wanted to see that document. As a matter of fact, I have done my homework too, you know. I will tell you what the courts say about post-dated checks. Hold on one second. It's very busy today, you know. The disadvantages of a post-dated check. The disadvantages stem from the fact that, as between the drawer, who is the customer, and the drawee bank, the post-dating of the instrument has the effect of instructing the bank to refuse payment if the check is presented before the purported date of its issue. A bank will be acting outside of its mandate if it honors a post-dated check before the date marked on its face and will not be entitled to debit their customer's account. Similarly, the bank cannot refuse to honor other checks drawn on the account as a result of it having honored a post-dated check before it falls due for payment. Isn't that what we discussed in the last class?
Yes, ma'am.
Okay, so listen now, banking law says that if the customer countermands the post-dated check during the period before the date marked on its face, the instrument will be dishonored by the bank. The holder's only remedy in such a case is to sue the drawer, correct?
Correct.
If you give a post-dated to someone and then you put a countermand on it, the only thing the person can do who's holding the check when they go to present it is they go back to the drawer. So in addition, the bank will be bound to dishonor the check if the drawer dies or becomes insane while the check is post-dated. That's another thing you have to consider. And for these reasons, it is inadvisable for a payee to take a post-dated check in satisfaction of an outstanding debt. So it says here that there is a degree of inconsistency in the legal treatment of post-dated checks. On one hand, between the holder and the drawer of a post-dated check, the instrument is considered as valid, as regular from its genuine date of issue. On the other hand, as between the drawer and the bank, the very same check is treated as unissued and is not containing a valid instruction until the arrival of the fictitious date of drawing. It is believed that it would be preferable to treat a post-dated check in the same manner in relation to all legal relationships. That it might give rise to. And this could be attained by statutory provision to the effect that a check is deemed payable on demand, irrespective of its purported date of issue, or by a provision similar to what Australia has done. So they're saying you put it in the legislation. Otherwise, the bank can be sued for not following the customer's mandate. Because it says that if I give you a post-dated check and the check is dated for the 31st of August and you clear it today, and I have other checks to come through that are dated tomorrow's date, the day after, and they bounce, I will sue you. That's called a wrongful dishonor of checks. Other issues could be safe custody issues, conversion or liability, defamation, over-crediting a customer's account or over-debiting a customer's account, the ATM machine, and of course, property issues, rights and remedies. All of those are legal issues that you can have in the banker-customer relationship. Now, when it comes to just the relationship itself, remember the banker-customer relationship is based on contract law. And one of the things can happen is you can say that there can be a mistake as to the validity of the contract between the customer and the bank. A mistake may be made as to the subject matter of the contract, the signing of written documents, and the identity of the parties. Where a mistake is proven to have occurred, the contract is considered void. So the person who is claiming mistake is going to have to prove that it was a mistake in order to say that the contract is void. A bank may be able to recover money paid by mistake where it pays a stop check, it pays a forged check, it pays a check with insufficient signatures, it pays an altered check, or it duplicates payments. In order for a bank to recover money made by mistake, certain conditions have to be made or satisfied. The bank pays the customer's money to another person on the mistake of fact, having believed the signature was genuine, or having believed that a payment had not been stopped. There's no requirement for the bank to prove that it was negligent in paying the amount, only that it has been mistaken in doing so. The bank pays without the customer's consent or authority, like when there is insufficient funds, believing that there are sufficient funds to cover payment, or pays a stop check, believing no countermand is in place. And third, the bank pays a check and later attempts to recover the funds, but does not act with great speed. A bank may not be able to recover funds where A, it made a representation to the payee that it was making the payment, and the payee changed his position in good faith and to his detriment as a result of receiving payment, or it paid another bank as a collecting agent for the payee, and the payee has withdrawn the funds. Notice a bank cannot recover funds. If it paid another bank as a collecting agent and the payee has withdrawn the funds, the bank cannot collect. It's not an example, it's an examinable term you should know. The paying bank can only collect from the payee, not the collecting bank. Where the paying bank is unable to succeed in recovering the paid funds due to mistake of fact, it may be able to exercise and enforce its proprietary right to trace the funds. And where bankers mistakenly credit a customer's account, it may re-debit the account or reclaim any funds which the customer has withdrawn from the account. However, the bank may be stopped from recovering the funds if the customer changes his position in good faith as a result of the credits. So always remember that whenever the bank is at fault, if the customer has changed his position due to the bank's mistake, sometimes the bank cannot get his funds back. Misrepresentation is a false statement of material fact made by a party to a contract or its agent, which induces the other party to enter into contract. The type of misrepresentations are, could be innocent, it could be negligent, or it could be fraudulent. An innocent misrepresentation is a false statement made by one person who had reasonable grounds to believe that it was true when he made it, and at the time when the contract was made. A negligent misstatement is a false statement by a person who had no reasonable grounds for believing the statement to be true. And a fraudulent misstatement is a false statement by a person who knew it to be false, or who believed it to be false, or who recklessly did not care whether it was true or false. The parties to the banker customer contract may rescind the contract where any of the foregoing types of misrepresentation exists, and damages are available for fraudulent misrepresentation under the tort of deceit. Negligence. Negligence is a tort where there is an omission to do something which one has a duty of care or obligation to do but fails to do. And in order to prove negligence, the defendant must have owed a duty of care to the plaintiff. And you know, the banks will have a duty of care to its customers. The defendant must have breached that duty to the standard of a reasonable man. And the plaintiff must have suffered some loss or damage as a result of the defendant. So remember, the bank had a duty of care. And in that duty of care, it had to be the standard of a reasonable man or above. They are a professional. Banks must be careful to avoid negligence by making negligent misstatements. For example, where there is a special relationship between the parties and one of the parties relied on the particular skill of the other party and suffered some loss, and that the other party knew of this reliance. And of course, professional negligence. The other one is undue influence. And this is the influence of one mind over another party, which makes the other party's genuine willingness and freedom to consent or contract adversely affected by such influence. And normally you see this in what we call special relationships. And I'll give you a case of a special relationship. Hold on one second, make sure my page didn't go anywhere. Go back this way. I had it marked. Hold on one second. My page went the wrong way. of influence. Undue influence. Hold on, it disappeared. On 3901. Okay, that's undue influence. Okay, got it. So I can find the case. Okay. The case is Barclays Bank versus O'Brien. A wife was persuaded by her accountant husband to execute a charge over the matrimonial home to secure a guarantee that the husband had given to the bank in respect of the company's debts. The wife executed the relevant mortgage documents at a meeting with the bank clerk at the bank's premises, but was neither given the opportunity to read those documents nor given an explanation of the transaction nature. Furthermore, the bank clerk failed to draw the wife's attention to a side letter in which she purportedly acknowledged her understanding of the transaction's nature and the bank's recommendation that she take independent legal advice. When the bank sought to enforce its security, the trial judge upheld its validity. On appeal, the judge concluded that both as a matter of policy and precedent, certain types of surety, such as married women and aged relatives, were treated as a protected class. Securities furnished by such sureties would be unenforceable by the creditor, provided one, he was aware of the nature of the relationship between the debtor and the surety and the consequent likelihood of influence and reliance, and two, the surety's consent was procured by the debtor's undue influence or misrepresentation. And three, the creditor had failed to take reasonable steps to ensure that the surety entered the transaction with an adequate understanding of its nature, so that their ultimate consent thereto was free and informed. And on this basis, the Court of Appeal set the bank's charge aside. And the House of Lords affirmed this conclusion. Its reasoning differed. The Lord Wilkinson emphasized as a starting point that any law designed to protect vulnerable sureties, such as wives and cohabitees, should not render the matrimonial home unacceptable to banks of security. Nevertheless, His Lordship considered that there should be circumstances where equity should be prepared to set aside a security granted by a surety, usually a wife, to a bank as a result of third-party debtors' undue influence, usually her husband. Naturally, this would occur if the husband debtor acted as the bank's agent in obtaining the security from his wife, with the result that the bank would be fixed with the husband's wrongdoing. So that means that whenever you're dealing with a matter with people who are in a very close relationship, such as husband and wife, or mother and father, grandfather, grandson, one of the things you have to look for is making sure that there is no undue influence.
Okay, question.
Go ahead.
In the matter of a mortgage, so I decided to move my mortgage from Commonwealth Bank to New Scotia Royal Bank. And me and my husband comes and we get some incentive for moving. So we get this money back for moving our mortgage there. He only has an account there. Can that money that they have for us be placed on his account, or does it have to be on an account with both names? Keeping in mind that the mortgage is in both names and we both are duly responsible for the payment of it.
But okay, so then the next thing you look at, where was the money coming from? One salary or both?
Both salaries.
To pay the mortgage. Then it should be joint. Then it should be joint.
Really after the dog gone? What else you say? That's what Charlotte say.
Excuse me, Miss
I am
Archer.
clear.
This
Where the
iPhone
pill?
giving feedback. I really would like to hear what y'all say.
iPhone no. So
Somebody.
So if we have a mortgage together, then whatever loan proceeds from that mortgage should go on a joint account and not on one person's account.
Agreed.
Because when you're correct,
Correct.
I close the inside with the leash. When I come upstairs, I can't. I bring up. What's that?
Who's that? Someone dealing with their dog.
Oh, what is this?
Sorry.
She didn't know she was on. She didn't know she had to sing them on. Go ahead.
Yeah.
Say it again. Everybody wanted to hear.
Okay, so if we're getting a loan, right? For me, if both of us are required for payment of this loan back, we're both duly responsible. If the money should only go into an account where both have access to it, not where only one. Because if I go back inside there now and says, okay, you'll put the money there from that, but you can't give me no information on his account, but it's both our monies.
Mm-hmm.
How do you handle that? Because I'm still responsible for that money that you put on his account.
Yeah, but see, the thing about it is that when you would have done that transfer, both of you should have gone into the bank and established a joint account.
When that was done, they came and said, okay, we have an incentive. We're going to put it on account. Do you have an account here? No, we don't. Okay, in order for us to put the proceeds on that account, you both have to be on the account. That's supposed to be automatic. You shouldn't, as a banker, make a decision to put that on a account.
I agree with you.
Right. Scotia did that.
Oh, no. I just knew you was coming back for that.
See, wow.
Okay,
That's
Yuri, why would...
Yuri, that's an actual case.
Yuri, so just listening to what she said, right? And you have done banking law now. If two persons are in a mortgage and you're doing a transfer, there are proceeds left, why would you put in the name of just one person? Knowing human nature, you put it in both, exactly.
And that case really came about with those insurance checks from Hurricane Dorian.
Mm-hmm.
So like persons were like missing a co-borrower's
I didn't know about that one.
And yeah, and persons were, and the check is supposed to be actually addressed to the bank because we're supposed to hold those funds.
Yes, okay. So stop right there now. Stop right there now.
Mm-hmm.
The insurance has to be in the name of the bank. Why?
Because due to the natural disaster, the bank has
nothing to do with natural disaster.
But the bank has to get paid out for the mortgage.
Yeah, but I want you but I want you to answer me in banking law terms now. You're about to finish this class. Why would the check be payable to the bank? Don't answer.
Because,
be quiet. Let him do it.
Because the bank, because the client still owes the bank the mortgage.
No, come on, go deeper.
I trying to realistically.
Okay. You know, we just talk about it today. We just talk about it today.
Because the check can't go in the mortgagee's name.
No.
Yeah, we know that, but why?
Because they can take the money and spend it.
Okay.
Knowing that they owe the bank money.
No. The home is owned by the bank, yes. But it's in the bank and the person, the mortgagee, is in bed together. So however there is, the check is going to be made out to both the bank and the person. Now, when it's done like that, they can't go to no other bank and cash it. They have to come to you. Then you guys have to negotiate the check.
Right. Whether you pay off the facility or you
not.
use it to
or to repair.
Right, repair.
Mm-hmm.
And
but remember now, I want you to remember, when you have a mortgage, that is a separate contract from the bank, a customer contract.
Correct.
And in that contract, that contract state what are the terms and conditions of that mortgage. And one of it is to keep the property in a good state of repair. You have to insure it. you have to pay all of the taxes on it.
Okay.
So if it came that you had a mortgage and that hurricane came and destroyed it, then you've already breached one of the covenants of your agreement because you should have insured that building. Now, you've insured the building. Notice that the agreement is between you and the bank.
Okay.
The bank is holding the legal interest in that property. You only have an equitable interest in that property right now. You have that equity of redemption. So by right, the check has to be made payable to the bank and to the mortgagor.
Okay.
And the decision as whether or not to repair or just pay off the mortgage is a decision that the bank and the customer comes to an agreement with.
And basically, that's the same as if you have a car loan and that car gets write off, that insurance check is made out to both the bank and the person.
Correct. Mm-hmm.
I sleep on this chapter.
So you what? You went to sleep?
No, I said I did not sleep on this chapter.
Oh. Don't sleep on this chapter because it affects you. Yeah. So, any more questions? So now you see when actions are brought against the bank, it can either be for misrepresentation of the facts. That's why if you're working in a particular area and someone wants particulars on, I don't know, something that happens in private banking or in the trust area, you cannot give people information that you don't have, or repeat what someone says from that department to someone standing in front of you. Because if that person relies on that statement, then they can come back if they lose any money or make a bad decision, they're going to sue the bank for negligence. So all of these things you have to think about when you answering persons. And then of course you could misrepresent the facts. Sometimes you know it is false, or sometimes you don't know it is false, but the customer can still sue you for misrepresentation. Sue the bank. And of course the bank does make mistakes. So on Wednesday, what are we going to talk about? Quieting title, the case, Westminster.
The exam.
We're going to talk about your midterm
Okay,
and the final exam.
all right.
The last chapter is only about, anyone read the last chapter?
I have up to chapter 10. Okay. There's another chapter?
Normally I just put a little something there on CRS and FATCA, but you don't need to do that.
Okay.
Yeah, so that's what we'll focus on. We'll focus on the final exam, what is going to cover. We'll go over the midterm, and before we do that, we'll look at the case of Montague on quieting title, just for information purposes.
Okay.
Okay? All right. So if I were you, I'd get started studying. You know where to start from? Yes?
No, ma'am. Could you go over that, please?
Oh my Lord, what you mean no?
We can start from the last 3 chapters we covered.
Say the last 3.
Okay. The last
Chapter
3?
7, right?
Okay, listen very carefully. The exam covers chapters 6, 7, 8, 9, and 10.
All of that?
No, it's not necessarily like that. When we go over the exam, I'll tell you where it's narrowed down to. But that doesn't mean you shouldn't start to review it. But like I said, be mindful that chapters 4 and 5 play a part in any banking question.
Oh my God.
No. Look at the Makushla situation. Even though we were talking about ATM machines, didn't it talk about the duty of care?
Yes.
Yeah.
You have to know the duty of care. You have to know the rights.
Yes.
That's what
The
I'm talking
customer
about.
relationship, right?
Right. And then you have to know the duty of confidentiality, if it is relevant. Those two chapters, chapter 4 and 5, remember I told you, those are the backbone of the banker-customer relationship. And you should know that out of your head. Now, some people on the midterm got it wrong. You'll see when you get your paper back. But those are things you have to know. Then the types of customers, we're talking about different types of accounts. Individual, joint, company, corporate. And such an account may only be mentioned that someone had that type of account. So based on these chapters, you should have an idea after Wednesday where the questions are coming from and be able to pull from all these other chapters what you think may be relevant under those topics that you need to carry with you in order to get a full answer. One observation I made from the midterm is that a lot of people either forgot first the common law case or they forgot the Bahamian case. And in some instances, some people forgot both. No cases were mentioned at all. And it ain't that many for you to remember. And then one of the questions was on bailment, and no one spoke, and some people did not even speak of bailment. There's no need to go quiet. We'll talk about it on Wednesday.
Are the papers at this? Can we collect them? No way.
You get it on Wednesday?
Oh, on Wednesday. Cool. Okay. Oh, so we in class on Wednesday. Okay.
Yes, I have it. I have it.
Okay. Cool.
Okay. And those who don't come, then I'll have to ask Ms. Dean to scan and send it to you. But hopefully everybody will be there. It'll be better. You hear it for yourself. What's on there?
Minister kneeled down tonight.
Yeah.
If he does, then you'll have to learn what's coming on exam by osmosis.
I'm so done.
All right.
All right.
So I'm looking at, I was thinking of putting a few multiple choice, but I don't know. I was just thinking of just giving you just the scenario questions and leaving it like that. 1, 2, 3, 4, 5, or 6, and leave it at that. I'll see.
That's a lot of writing.
How to get a lot of writing? Why you say that?
It is a lot.
No, it's not. It is not. It is not a lot if you answer it right. I don't know what kind of answering this is y'all were giving me. When I started to read these midterms, I said, what are they talking about? I had to check again. I said, what is this? What are they talking about? Ooh.
You mean to tell me it didn't make sense? It didn't make sense with me, right?
In some cases it did, and in some cases it did not.
My God.
Serious.
No, not serious. Not to say you all don't know, you know.
We just ain't apply it properly.
We just ain't applying it properly. Because you know why? It'll be just like when you enter law school. They always say, everything that you learned before, take it out of your mind completely. And start again. Because a lot of things that you write it because you know that's what you do. But is it law? See, that's the question. Is it law? A Yuri paper I just passed. I went past that fast.
Keep going. No look back. Don't look back at it.
Yuri told me to go fast, you know, he did.
He did say put it in the junk.
Yeah, and another thing was this. Remember when I gave her that handout on comparing the elements of a contract to
Totally
banking?
Yeah.
Yes. But shall I get all kind of funny answers? I don't know what that is. Because all you had to do was take, you just had to take the elements of a contract on one side and then line it up with what happens in a bank.
You have to be kidding me.
That's all you have to do.
I didn't, but that's too simple. I think we overthink it,
No,
guys.
All that for 15, that little bit of thing for 15 points, eh?
And you have to
all you had to do was then basically
step by step.
Step by step to do the account opening process.
Yes.
Yep.
What is this?
Monkey.
I tell you, cheat. Anyway, we oversaw it, guys.
What is this?
What
That
happened to you?
time when you see that 15 points, you think you're big right up.
When you say 20 and 25, that's big right up. Who this person is? Who's Newton? Newton on this phone? No. Okay.
Thompson here.
I don't know. I don't know what your problem is.
Look, are you laughing at me?
No, I'm not laughing at you. You saying Thompson is here. Yeah, I see Thompson. Let me look at Thompson. You can get it on Wednesday.
Why you don't know? Why shoot?
This Thompson. Oh, you have to sit next to Yuri.
What?
That's all I have to say. I'll see y'all on Wednesday.
I know that's supposed to mean.
I don't know what it means.
Too, boy.
I tell you.
I am warning you now. Tell me now before Wednesday comes. Tell me now before we press this button. Who wants a research paper?
Man for sign up?
No, in addition to
this extra points.
Extra points for your midterm exam.
This extra point.
Hold on, that thing we do prior to the midterm, that can't even make up?
No.
Well, what is this?
Excuse me.
Yes.
Hi, so you're saying we could get a research paper for makeup brand?
Yeah.
Okay.
I might need that paper.
Yeah, we want it. I can need that.
I can need that paper.
I can need that little thing.
But you only even know what you'll get on the midterm?
That's not my gala.
Hold on. But then I not ask you all on the first day of class. I said, what did I say?
You can.
We wasn't expecting the exam to be like that.
Like what? That was easy.
You can message
Section 1 was easy.
Miss Ashley, that was easy because you are a bank. I mean, you are a lawyer.
You've been in this long time.
Yeah. So dang, you hit the nail right on there. You're a banker and a lawyer.
I'm not even a banker. I must need.
Hold on.
I must need 6 makeup questions.
That excuse saying I am not a banker. I don't take that.
Well, I need 6 makeup questions then. How about that?
This test was so easy till it wasn't funny.
Yeah.
It was easy. Admitted it was easy. You just have
number one.
You have to think.
Yeah, I think it was easy, but we was overthinking.
Okay, so hold on. Remember, I told you all that what the man named Maurice Clinton case was coming. Did I not say that?
Yeah.
But half of y'all forget Maurice Clinton case.
Oh boy.
I mean, totally forget the man.
Something was on that question, Maurice Clinton?
Yes, it was.
Oh, okay.
It was there.
Okay. Yeah, we need the paper.
So I said on my very first class, I said, do you all want a research paper? I say, students normally take the research paper. No, Second class, I asked. No. Third,
Please
no.
send the research paper.
Huh?
Please send the research paper.
Y'all say adamant. Don't need it. Don't need it. Okay. And I started turning these pages. I said, well, what happened? Oh, and then the question with the bank. Bailment with the jewelry and the man coming in. I don't know what some people.
Oh wow! Listen,
I
that
got
was
on that one.
no, nah, that
That
was
took me
yeah,
for
shoot.
I don't know. I must read that
That
5 times. I
question
still
took
didn't
me
know what
for a
happened.
loop.
I said, God.
Oh,
How
that
should
was
we?
you.
Oh, we going over that.
Like what 5, 6 times to try and answer that.
Why? Let me see what did you write? Let me see.
Oh my God.
Please put the paper in the junk. So.
I can't put in the junk. I have to add your little points here. I have to put your points down and add it to your paper.
Your little
Okay. I want 350. I want 350 points for that.
What number you want to see? I haven't added it up yet. I don't know.
So, Miss Archer, are we gonna go over the research paper more on Wednesday, or how do you
Yes.
go? Okay.
Yeah, since y'all want one now. I have to think of what
I know about them.
Do you need one?
I need two.
You're killing me.
Why need two of them?
Oh Lord, you're killing me.
You're making fun of us, man.
Yep.
I am not making fun at all. I wouldn't talk with the pure contract questions that y'all had to do at home.
Oh my
That was
God.
15 points.
It was bad.
Anyhow.
Jeez.
Yeah, nobody got over. No one got more than 10.
Jesus.
No more than what?
No one even made 10. And I'm missing some.
Oh my
Where's
God.
your Yuri? I don't have Yuri. When I give them out, y'all can tell me if I miss somebody.
What's that?
But
What's that? What's that?
the contract question.
You're in trouble.
That they came to class late.
Oh, yeah. Well, you're missing that. You could probably get
What?
that and get another 3 points.
The contract question.
You're in trouble.
McQuell, you ain't saying much tonight. What happened?
3.
Hey, McQuell, what happened?
I'm just listening.
Why?
I'm taking it all in.
What that means?
With the exams?
Mm-hmm.
Oh no.
You done bury us and you want us some things to say?
What do you mean how I bury you? I did not bury you. I'm challenging you.
We need this final up.
Okay, so McQuell, you and I have to have a conversation on this jewelry business.
Yes. Yeah.
Yes, yeah. Because I have a big question mark on that. You're going down the wrong road, a rocky road. Okay, you didn't do too bad there. What is what?
Tell Ashley in private. Don't get announced to them.
I'm just saying McQuell. I know McQuell was kind of quiet. So I said, let me just look at hers. I have another question. Huh? I just looking. Okay, so she remembered the case. Something ain't right on that question. And y'all, some people didn't do very good on those little small little questions at the very beginning. But y'all left so many blanks.
Oh, jeez.
Why? And when the question says list and discuss, it don't mean just drop it down, you know. Everybody seemed to do it except a couple of people. The golden rule, literal rule, and use them generous. You have to tell me what they are.
That's all I remember.
So
that's really all I remember.
Yeah.
The golden, the literal, the mischief, and
I mean,
Sometimes.
I think we all got just the names were more important. I don't know.
Because
Not
I
that
can
we,
do the short answers.
not that we would have known. Have to know the meaning.
No, like God, you should find them, yeah.
Yeah.
Yeah, some people did, and they just did the one word, literal, absurd.
The mischief, the golden, and the unit,
Right, and what does
the
it
unit
mean?
generous.
Yes.
Yeah, I can say
What does it mean?
Yeah, yeah.
Okay, and be mindful in the final exam if you have to, but I doubt you would have to, but you might have to, I don't know. Please do not write the name of the act wrong. The act name is the Banks and Trust Companies Regulations Act, BTCRA, not BTCH. That sounds like something to do with the hotel
That's
administration.
back.
I don't want that one on there. Yeah, so. Okay, and then a lot of people didn't know what the meaning of a bank.
Oh, that-
Mm-hmm.
That was a tricky question.
That was not.
The acceptance of deposits or something, I know.
Yes, what does a bank do? To accept, deposit, give loans, all of those stuff.
And I have that on my paper, I ran open in my mouth.
Well, I don't know if it on your paper. When I give them back, you can pray over it. Let me go and think of a research question now. That won't take you all too long. Now remember. When you hear research question, that don't mean I want 30 pages. That don't mean I want 50 pages. But please do not give me 3 sheets.
We just
Why
need a
else
paragraph.
what?
We just need a paragraph. Right?
I said,
Asian.
don't give me 30 and don't give me 50, but do not give me 3.
Oh, you want 4?
At least 20.
Some people do 20, some do 15, some do 12, long as it has meat in it. I don't want fluff. Don't fluff it.
Oh,
Don't fluff it. Because I know what I'm looking for. All right. Let me see if I can think of some options. How that sounds?
Please.
Okay, I'll give you all some
yeah, so we
options
can
and
pick
something
it.
that you all,
Fine.
yeah, something that you all could do rather quickly.
Fine.
Okay. All right. So I'll see you all Wednesday, 6 o'clock sharp. So
Okay,
y'all
good
can
night,
get out
everyone.
and do your paper.
Wednesday's
you get-
revision, right, Miss Archer?
Wednesday is, I will tell you, the areas on the exam. Mm-hmm.
Okay.
Sounds good?
Yes, ma'am.
Yes, ma'am.
All right. Okay.
Okay.
So when I let y'all out on Wednesday, that means go and do your paper.
Yep.
Because the exam is the following Wednesday, so you don't have time.
Oh my
Or
God. Okay.
Okay? All right. Good.
The 3 minutes.
All right.
Okay.
So,
Good
talk
night.
to y'all later. All right. Good night. Okay.
Good night.
Good night.